just by way of background of our firm, we've been working hand in hand with the ACMA for probably decades now. I think it's safe to say. And like them, we've grown up with the industry from representing catalog merchants, starting with LL Bean to the present, where the catalog is considered by many to be an artifact of the past, although not by many of our clients. But which is a long way for me to say that we were there step by step in litigating Wayfair to the Supreme Court. My late colleague George Isaacson argued that case on behalf of the respondents, unsuccessfully, regrettably, from our perspective. But Public Law 86-272 appears to us to be the next front in this conflict between the aggressive state tax agencies who are looking for ways to entice, bully, prompt, choose your verb, out-of-state retailers in particular into registering and remitting state income tax. This litigation in California stems out of the 2021 Multi-State Tax Commission report that recommended, from our perspective, essentially gutting Public Law 86-272 by redefining what it is to do a business activity in a state to include activities that most definitely don't happen in that state, such as responding to an email inquiry on a website or using marketing cookies to track customer behavior in certain ways. As much as the states might like to change the policy in this area, we don't believe, and the ACMA doesn't believe, that a public guidance document or a state tax regulation from a state level is a way to do that. This is a federal statute under the Supremacy Clause. It provides a clear rule for, and I think one thing the states tend not to appreciate is the ACMA and our client base are businesses of all sizes. And what Amazon might be able to seem to do with the snap of a finger, a relatively small boutique business in Maine or some other state that opens a website with a retail outlet isn't able to do. And Public Law 86-272 is a pretty bright line rule. If the only activities your business has in the state relate to soliciting the sale of goods for purchases completed outside the state, you shouldn't have to worry about that state's income tax. And now the presence of cookies or live chat shouldn't change that calculation. And so that's why we launched this litigation, and we were delighted to have the ACMA support in doing that.